Hello everyone, welcome to Mastermind. So in this video, we'll discuss fundamental rights, and this is part 2 in the fundamental rights series. Now let us brush up with the part 1 now. In part 1, we saw that fundamental rights are mentioned in the part 3 of the Constitution and from articles 12 to 35. From articles 12 to 35, and this has been inspired by United States of America's Bill of the Rights. And in that we have seen that article 12 defines what exactly is state, till here, and other basics we have seen, that is the features, the important features of the fundamental rights, etc. we have seen. Now in this part, let us start with another article, the next article, which is article 13 of Indian Constitution. Before we discuss about article 13, there are two words, the definition of which let's look at. Then it will be easier for us to understand article 13. So what are the two words? So the first word which you have to understand is what exactly is wide. What does wide mean? Then second one is what is derogation. What is derogation? So let's know the meaning of wide and derogation. Wide means not valid. Not valid. You can also call it invalid, correct? Void means it is not valid or it is invalid. Next, derogation means it is an act of talking about or treating someone in a way in which you do not show respect. You do not show respect. That is derogation. Okay, so void means it is invalid, and derogation is when something on which the respect is not shown. Now this article 13, it says that any law, okay, which is inconsistent, any law which is inconsistent with or in derogation of fundamental rights shall be void. Now what is it saying? What is it emphasizing over here? Now in article 12 we saw what exactly is state. In article 13, in other words, what it is saying is that if legislature or any law making body, if they are making law and this particular law is not on par with fundamental rights, or if it is not respecting fundamental rights, if it is not inconsistent with fundamental rights, then by default only it will be invalid. That is, whenever there is a law which has to be made, it has to keep fundamental right in mind, because automatically if it is not respecting fundamental right, it will become invalid. Now who will say it is invalid? That right has been conferred on courts. One is Supreme Court, which has article 32, they can declare it as invalid, and also High Court, which is 226, article 226. They say that any law which is inconsistent with or in derogation of fundamental rights, they shall be void. So this power is mentioned. One second. Okay, so this is provided. This is upheld by the courts, and this power which the courts have, it is called as doctrine of judicial review. It is called as judicial review. So High Court or Supreme Court, they can declare a law as unconstitutional. When will they declare it as unconstitutional? When it becomes inconsistent with that of fundamental rights, or if it is they can declare it as invalid on the ground of contravention of any of the fundamental rights. any of the fundamental rights. Now we saw that there is any law, correct? When we were looking at the definition itself, we saw that Article 13 declares that any law that is inconsistent. We saw what is inconsistent, we saw what is derogation, what is void, etc. Now, what is law over here? So, who does this law? Correct? That is something which you have to remember. So, this term law also is mentioned in Article 13, and similar to that of Article 12, in which they mentioned wide range of sense for the word, for the term state. Similarly, in Article 13, the term law also has wide connotation. So in this, it includes if there is a permanent law enacted by either parliament or state legislature. If there is a permanent law which is enacted by parliament or state legislature. In case there is a temporary law. What is temporary law? It is ordinance, correct? It is ordinance which is issued by president or state governors. In case there is a law by statutory instruments. In their order, they might be saying bylaw, rule, regulation, notification, etc. Fourth one, in case of non-legislative source of law also. In case of non-legislative source of law, that is custom or usage having the force of law. That is, law itself has a broader definition. So any of these which is inconsistent with that of the fundamental rights, with any of the fundamental rights, then it can be declared as invalid by the court. Now, in this law, we have seen that there is variety of definition, but what if there is amendment? What if there is amendment to any law, and if that amendment brings inconsistency with that of fundamental rights, then so Article 13 declares that constitutional amendment is not a law. It is not a law. Okay, this is very important. Article 13 declares that constitutional amendment is not a law, but this constitutional amendment can be challenged on the ground that it violates fundamental rights, though it is not a law. And if even after being not a law, even after that, if it is affecting any of the fundamental rights, that is, it is violating any of the fundamental rights, that also can be questioned. So I hope Article 12 and 13 are clear. 12 is related to the definition of the state, and 13 is related to the legislation or law being inconsistent. Now there is a right to equality. In the previous part, we have seen the proper definition. Of different rights. That is, there is right to equality, right to freedom, and we have seen a mnemonic also for that. So under right to equality, there are articles 14 to article 18. Article 14 to article 18. Now we have seen article 12 and article 13. Next one is article 14. Article 14. This is very, very important because these article 12, 13 and 14 are nowadays being asked a lot of times in the examination. So article 14, there is, the first one is equality before law and equal protection of laws. That is, article 14 itself says that the state shall, what is this state? What constitutes the state? It is mentioned in article 12. The state shall not deny to any person. The state shall not deny to any person equality before law, or equal protection of laws. Now this provision, it is applicable for both citizens also. It is applicable for citizens also and foreigners also. So it is telling about two things over here. That is, there is equality before the law, and then there is equal protection of laws. Now, what is equality before law and what is equal protection of laws? Both the things we have to understand. So the first one, equality before law. Equality before law, this concept itself is taken from Britain. So it is a British origin. It is a British origin. What it is saying? It is saying there should be equality before law, in front of law. Before in the sense in front of law. That is, there is no special privileges. No special privileges. No special privileges. That is the absence of any special privileges in favor of any person. In favor of any person, there won't be any privileges which is provided to any person. That is, everyone is treated equal only. That is, equal subjection of all persons. Equal subjections of all persons to ordinary law and in ordinary court only. Ordinary law and which is administered by ordinary court. That is, this is speaking about equality, complete equality. Nobody is rich, nobody is poor in front of law. That is being said by equality before law. The third statement says that there is no person above law. No person is above law. That is, everyone has to be treated the same only. For the same crime, they have to be treated same only. Now, there is another concept, that is equality before law. I hope you have understood. That is, there should not be any special privileges and equal subjugation of all persons and law, all the persons, and they have to be subjected according to ordinary law, which is administered by ordinary court. No person is above law. Next one is equal protection of law. Equal protection of laws. Now, why is it different? Why is it different? So this is taken from American Constitution. This is taken from America. So equal protection of laws. That is the equality of treatment under equal circumstances. Equal treatment for equal circumstances. Equal circumstances. So, for example, this is just an example. 1 second. Okay, just an example. Now, let us say the fine for not wearing helmet is rupees 500. Fine for not wearing helmet is rupees 500. So, if you go on a normal bike also, it is 500 only. If you go on a EV bike also, it is 500 only. That is, for not wearing helmet, the fine is 500. Doesn't matter on what vehicle you are going. So, if individual has committed crime similar to that of the other person, then both of them are treated equally. Equality of treatment under equal circumstances. If there is equal crime, they are treated equally only. So, both in the privileges conferred and liabilities imposed by the law. That is, whatever is the liability, we discussed about the helmet example. Now, similar application of same law. Similar application of same law to all persons. To all persons. Now, the same example of helmet, that cannot be changed for someone else because they are special or something. Correct? So, it has to be applied similarly because it is the same law which has to be applicable for everyone who are similarly situated. Third most important point is that it says like should be treated alike. Like should be treated alike. That is, if there are 2-3 people of, let us say, different economical background. Let's say this is poor, this is rich, this is very rich, this is VIP, etc. Okay, and each of them have committed the similar crime. It is a similar crime. For example, they might have stolen something. This is just an example, should not be taken that seriously. So at that point of a time, all of them are treated equally only because they have committed the similar crime only. So like should be treated alike. Like should be treated alike. So if you look at equality before law, it is a negative concept. It is a negative concept in the sense there is a restriction on this. That is, it says there is no special privileges, equal subjects, all powers, and they are treated on the ordinary law administered by ordinary court. Again, it says no person is above law. So whenever there is these kind of statements which are mentioned, it is a negative concept. In case of the second one, which is equal protection of law, it is a positive concept. That is equal treatment for equal circumstance, like should be treated alike, similar application of same law to all the persons. Next, there is a concept of rule of law. Very, very important. Most of the times there are a lot of questions which are asked on rule of law. This is taken from equality before law. This is taken from equality before law. Now, just now we have discussed that equality before law, this is a negative concept. Negative concept, that is, there are restrictions with respect to this. So now this equality before law, this is the element from this, the rule of law is an element from equality before law itself, and this was propounded by A.V. Dicey. A.V. Dicey, who was a British jurist. We'll look at what exactly is rule of law in simple points so that it will be easier for us to understand. So the first one, it says that the punishment can be done only when there is a breach of law. Breach of law. There is a breach of law. That is, it says absence of arbitrary power. That is, no man can be punished except for breach of law. Only if there is a breach of law, that person can be punished. So only if there is violation of law, that person can be punished. Otherwise, they cannot be punished. Second one, it says that equal subjugation of all citizens. Equal subjugation of all citizens. Everyone has to be treated equally. Even if they are official, non-official, rich or poor, high or low, they have to be subjected in front of the law equally. That is, they have to be taken to the ordinary law of the land, and they have to be administered by the ordinary law courts itself. Ordinary law courts itself. So the third one says that the primacy of rights of individual, that is, constitution is the result of rights of individuals. It says that the constitution itself is the result of rights of individuals. So the rights of individuals is mentioned in the constitution itself, and it should be enforced by the court of law. It should be enforced by the court of law than the constitution being the source of individual rights. So these rights are enforced by the court of law. This rule of law, which is in Article 14, constitutes basic structure of the constitution. Basic structure of constitution. Now, what is basic structure of constitution? So the rules, regulation, or the articles, or whatever is mentioned under basic structure, which is mentioned by the court, whatever comes under basic structure of the constitution, that says that it is essential for the constitution to exist as a whole. So whenever there is amendment, this part should not be changed. That is, this should not be destroyed by an amendment. So if an amendment tries to destroy the basic structure, then that amendment itself can be questioned. Okay, so I hope you have understood what exactly is equality before law, equal protection of laws, and the rule of law. But while we were looking at fundamental rights in the first part only, we saw that we have to be looking at exceptions, because exceptions are very, very important for us to remember. What are the exceptions? What are the exceptions to equality? What are the exceptions to equality? So in this, you have to remember that the rule of equality before law, it is not absolute, and there are constitutional and other exceptions. First one is the President of India. The President of India and governor of state, they enjoy many immunities. Many immunities. According to Article 361, they have the immunities. Now, what immunities do they have? First one is that the president, or president I'll write it as P, and governor I'll write it as G. Okay, so president or the governor is not answerable to any court. So if there is a case on president at that point, when they are in the term, at that point of time, they are not answerable to any court. Second one, there cannot be any criminal proceedings. There cannot be any criminal proceedings which can be instituted or continued against the president or the governor in any court during their term of office. For example, let us say XYZ is a president who is having a criminal case, let's say in 1800. Just an example to understand. You should not say that, okay, we got constitution in 1950, etc. This is just an example. Now, they already have a criminal case in 1800. They became president in 1802. They are president till 1804. Now, they had a case over here, but it cannot be continued when they are in office. It cannot be continued when they are in office. That is, during their term of office, there cannot be any criminal proceedings against them. Then, no process for the arrest or imprisonment of president or governor. No process for arrest or imprisonment of president or governor. Not just criminal proceedings, there cannot be any civil proceedings also. There cannot be any civil proceedings also against them. No civil proceedings against the president or governor shall be instituted during their term of office in any court in respect of any act done by them in their personal capacity, whether before or after entering upon his office, until the expiration of the 2 months next after notice they have to be delivered to them. This is the first exception, which is related to the president and governor. Second one is, there is no person shall be liable to any court or criminal proceedings in any court in respect of the publication in the newspaper. Publication in newspaper. This is exception for everyone, because that is why they are telling no person shall be liable to any of the civil proceedings or criminal proceedings, because they have put across in newspaper. In this, they also mean radio or television of substantially true report of any proceedings in either house. This is the second exception. Third one is related to member of parliament. Third one is related to member of parliaments. Now, no person of parliament shall be liable to any proceedings in any court in respect of anything which they have said or if they have voted in the parliament. So, if a member of parliament has said something in the parliament, or if they have voted for something in the parliament, that cannot be questioned in the court. So they are not answerable also for that. So this immunity is being provided for them under Article 105. Next, fourth exception. In case of state legislature, that is MLAs, you remember it as MLAs, MLCs. No person of legislature of the state shall be liable to any proceedings in any court in respect of anything said or any vote given in the legislature. Or even in the committee. That cannot be questioned. Article 194. Next exception is that the foreign sovereigns or the rulers, they enjoy the immunity from criminal and civil proceedings, and also the United Nations organization and the agencies, they also enjoy the diplomatic unity. So these exceptions are also very important for us to remember. So in this part of the video, we discussed about Article 13 and Article 14. Article 13 and Article 14. Article 14 was with respect to equality before law and equal protection of laws. In that we saw equality before law, equal protection of law, rule of law, the exceptions to equality. In that we saw about president and governor immunities, then publication in the newspaper, member of parliament's immunity, state MLA's immunity, and United Nations organizations and foreigners or foreign sovereigns or rulers or ambassadors or diplomats, they also enjoy the immunity. So this was Article 14. In the next part, we'll discuss about our next few articles. So probably we'll be discussing only about Article 15, because Article 15 is a little huge. In that we have to be discussing about reservation for OBCs in the educational institutions, and the economically weaker sections also we have to be discussing. So that we'll be discussing in next part, which is Article 15. So at the end of this e-paper, there are a few multiple choice questions for you to answer. You can attempt those. Thank you. I'll see you soon in the next one.